Okay, good afternoon. Welcome to today's webinar. It is 2025 Workforce Readiness, Navigating the Election Outcomes and Critical HR Topics. So I know that we are all happy that the election is now over. Now we can focus on what we need to do. And we're excited to have Lynn Luther join us from Eastman and Smith to talk about some of these things. I'm Stacy Bigelow. I'm with the Advance Group. I'm the CEO, and I really do appreciate you taking your time today to join us. So a few housekeeping things. Please ensure your audio and video are muted to avoid any background noise. We will have Q&A at the end of the presentation. Feel free to submit those using the chat box. If you encounter any technical difficulties, please use the chat box and we'll try to navigate that. And this webinar will provide you with 1 hour of HCRI credit, which I'll send out to you later today. I am recording this, so if you would like a recording, please feel free to reach out to me or any of your Advance reps. So our speaker today is Lynn Luther of Eastman Smith. Lynn exclusively concentrates her practice in representing management in labor and employment matters. Lynn represents employers in federal and state courts before administrative agencies and provides innovative consultation on how companies can best manage their workforce. She's represented clients in many industries, from Fortune 500 companies to small family-owned businesses, and she has a particular focus in automotive, manufacturing, and healthcare sections. I've known Lynn for many years, and we are very fortunate to have her share her insights with us today. So without further ado, please join me in welcoming Lynn Luther.
Hi, Stacy, and thanks to you and everyone at the Advance Group for inviting me today. I certainly want to make this as beneficial for all the attendees as possible, so please make sure you use that chat function so that we can answer any questions that you might have.
Great.
So,
I'm going to turn it over to you, Lynn. Okay, I made you the host. Do you have access?
Yes, I do. Thank you.
Okay, thank you.
So, as I said, we're going to be talking about a variety of topics today. Certainly, as Stacy pointed out, we're all very glad that the election is over, but that means we have a lot of questions on where things are going to stand going forward. So we're going to start off with some things that appear to be top of mind. Of course, we have no crystal ball to know if all of these things are going to come to fruition, but we do have some clues based on what we saw in the last Trump administration and then what was discussed during the campaign. So starting off, we're going to talk a little bit about pre-employment considerations. There were quite a few agenda items discussed by President Trump during the campaign and just from what we saw last time that show that there is going to be a renewed interest in this topic on a couple of fronts. First and foremost, background checks. Privacy and personal liberty are two things that are very much a part of the Republican agenda. So we do think there's going to be a renewed focus on this. Background checks are interesting because they're subject to a wide variety of laws. And part of that is because they are subject to federal law with the Fair Credit Reporting Act. Another aspect of it is that they're subject to federal EEO laws, equal employment opportunity laws. And then to further complicate things, we do have a variety of state laws that limit the amount of information that we can collect during a background check, as well as what type of information can be considered during employment situations, even if we are able to collect it. So with that, the Fair Credit Reporting Act is the primary statute we have to worry about, and that's the one that requires employers to have a signed authorization form from the employee before any type of background check is collected. It also requires employers to make sure that the employees are provided with a very specific Fair Credit Reporting Act notice, which is a standalone form that advises employees of all their rights under the Fair Credit Reporting Act. It doesn't stop there, unfortunately. If an employer does want to take action based on the information that it receives in a background check report, and most often that involves the employer deciding they want to rescind an employment offer, they first have to give notice to the employee called a pre-adverse action notice. That action notice just tells the employee that, look, we're thinking of taking adverse action based on what we found in the background check report. Here's a copy of your background check report. If you dispute anything that's there, you then can go to the reporting agency to say, hey, this information's incorrect, and see if you can clean this up. After a reasonable period of time, the employer can then take adverse action, which again requires giving specific notice to the employee and giving them their Fair Credit Reporting Act notice once again. So there is a lot of litigation in this area because a lot of employers skip those steps. And so we need to be very careful to follow that procedure just so we don't have a technical defect under the Act. If an employer is going to disqualify someone based on what they find in a background check, we can't simply make that decision because we see a criminal conviction in someone's record. And that's where the EEO laws come in. What the EEOC has told us is that we have to be very specific to match the conviction found on the background check to the specific job that the employee is hired to do. So for example, if we are trying to hire someone to be an accountant or someone who will have access to cash or financial information, it would certainly be reasonable to disqualify a candidate who had a conviction for embezzlement in their record. However, if that person was going to be sweeping the floor, or doing a janitorial job, or doing a blue-collar job in a production area of the facility and would not have any access to financial information, in that case, it becomes a little less clear on whether we can use that embezzlement charge to then disqualify that person from employment. So there is no one-size-fits-all answer to this. What we're always looking for is, can we tie that conviction to whatever job the person is doing? The other thing to keep in mind is that background checks are not one size fits all. We always think of them as just being a background check and think it's going to catch everything. Whenever we're using these consumer reporting agencies to collect this information, we're always advising them which jurisdictions they need to search. Most often, they're only going to be looking in the state or the area where the employee currently lives. If we want a more expansive search, and sometimes we do, especially for higher level positions, we have to specifically tell them that. So make sure you're not just automatically assuming that this background check is going to catch everything, because very often they do not. The next issue you need to take a look at is to make sure that you understand your obligations as a company under the Fair Credit Reporting Act. Simply because we're delegating this function to the consumer agency to run the background check, or we're relying on a third party like a staffing agency to run those checks, that doesn't mean that you're automatically off the hook and you don't have to follow these Fair Credit Reporting Act requirements or the EEO laws. That is not an obligation we can shift to anyone else. So we're relying on the companies to do these background checks thoroughly, but when we're making decisions based on the information that they collect for us, the company needs to make sure they're likewise complying with those obligations. And then finally, social media searches. It is always everyone's first instinct when we see something questionable about a candidate that we want to jump on and Google their names and see what kind of social media activity they have. Now, there's nothing per se illegal about that. The danger is that sometimes you can find out things you don't necessarily want to know. An employer's best defense to any type of discrimination lawsuit is to be able to honestly say, I had no idea that this person was disabled, or this person practiced a certain religion, or this person has a specific sexual orientation. Those are all aspects of a private life we don't necessarily know when we're in an employment situation, but if we jump on social media and start looking, well, sometimes we discover those things. So if you're going to look on social media, make sure that you're limiting that inquiry to one or two people who have a position with the company where they can keep that private and will only tell the decision makers what they need to know. That's certainly the best practice to make sure that we're not unwittingly putting ourselves in a position where it can be more difficult to defend claims down the road. All right, jumping ahead to the next pre-employment issue.
Lynn,
Immigration.
can we put questions for the audience in the Q&A? Looks like we're having a problem with the chat feature, so if they could just
Sure.
put them in the Q&A, that would be great.
Okay. On immigration, obviously this was a huge point for the last election. So we're going to be seeing increased scrutiny in this area going forward. There will be greater scrutiny for employers of the I-9 process, and we expect to see an increased number of audits from Homeland Security for private businesses. One large aspect of the President Trump's agenda is to hire more employees for Homeland Security so that they have more ability to conduct the necessary investigations to guarantee I-9 compliance. They have also stated that they are going to increase civil and criminal penalties for employers who use undocumented workers. So another reason to make sure that you are auditing your I-9 records and bringing everything into compliance. One issue that might be difficult for many employers going forward is the ability to use the H-1B visa program. The H-1B visa program is a way for companies to bring in high-level specialized skill employees from foreign countries to perform work here in the United States. It's very commonly used to bring in engineers, medical personnel, and people with advanced degrees to fulfill certain needs. The temporary agenda that's currently publicized for the Trump administration is that they plan to limit that program. So to the extent you have any plan to use this visa program, I would certainly do so sooner rather than later before those changes are implemented to the extent you can. Same thing with the ability of other authorized workers and employment-related green cards. We expect those are going to be significantly curtailed. And to the extent the large deportations do occur, that's certainly going to impact the labor pool. We already see employers have had difficulty recruiting for many jobs, especially lower level jobs in manufacturing and other similar industries. And if we're talking about a deportation of people in the $500,000 or multi-million-dollar mark, that's going to limit the pool of available labor for us. In the past years, I've often gotten questions from manufacturing clients saying, hey, can we bring people in from Mexico to do these jobs that we just can't fill? That was always difficult before because there just weren't many visa programs to serve that purpose, but that ability is going to be limited even more going forward. Okay, next up is Department of Labor updates. First and foremost, and the one that everyone is talking about the most, are certainly the changes to the overtime rules, and specifically the white collar exemptions. Now, just about every company has a number of people who are exempt from overtime because they meet one of these exemptions. Although there's lots of the exemptions, typically the list, it falls here. It's executive employees. Those are any member of management, any manager who supervises 2 or more full-time employees can fall under this. Administrative exemptions are the exemptions that we typically see running the business, for lack of a better word. So HR employees fall under this category. So can certain engineers or other high-level professional employees. The professional exemption is for people with advanced degrees. So people who are accountants and have a CPA can fall under the professional exemption. Certain computer employees, this is not your IT help desk person necessarily, but if you have an IT director who is responsible for overseeing the IT program at your facility, they can fall under that. Outside sales is another exemption. This is someone who is truly outside of the office doing commission sales work. They can be exempt from overtime. And then finally, highly compensated employees. These are high-level employees who are paid well into the 6-figure mark. and they can likewise qualify for unemployment if they meet those salary thresholds. So in order to qualify under the white collar exemption test, they not only have to meet one of the job duties tests under those categories we just talked about, they also have to be paid on a salary basis. So what that means is they have to be paid their salary regardless of the number of hours they work in a work week. So we can't start deducting from their salary if, for example, they take a day off and they don't have vacation to fill that void. They need to be paid that amount, subject to very few exceptions, pretty much on a regular basis. We also have to make sure that the salary level meets a minimum equivalent. Right now, or excuse me, it was $684 per week earlier this year, which equated to $35,568 annually. That's where we've seen a change in the last year, and we see more changes coming is with this salary level. So when this law was passed, the new rule, which was passed in 2023 and took effect in 2024, didn't change any of the tests, the exemption test for white collar employees. What it did is it started making changes just to that salary level aspect of the exemption. And so here's what we see. So effective July 1 of 2024, so this has already been in effect for a few months, that weekly salary amount increased from $684 to $844, which equates annually to just under $44,000. The highly compensated employee exception increased from a little over $107,000 to $132,964. Again, all of this is already in place. So hopefully you're already paying your exempt employees or your highly compensated employees above these levels, because this is what is currently in effect. After January 1, however, we're going to see additional changes. Right now, the law is going to step up that salary amount even higher. So the weekly salary will increase to $1,128 in order to qualify for the overtime exemption. That equates to an annual salary of $58,656. The highly compensated employee threshold will also jump up to $151,164. Now, there is legislation pending to overturn this as being overbroad. We didn't see any of that legislation result in any changes before the July 1st levels took effect. Many of you may remember that back in 2019, we were sort of in this same spot. The Obama administration issued pretty hefty changes to the salary levels at that time. Back then, a court did issue an injunction to stop those salary levels from going into effect. And then by the time the first Trump administration took over, those legal challenges to the injunction were just withdrawn. So the existing levels remained the same, and we never saw those salary level increases. And I know that was a bit frustrating to many of our clients because they were all geared up and ready to go. And we got that injunction in the 11th hour, so the changes never took effect. We could certainly see the same thing happen here with the January 1 increases that are currently scheduled. Things are a little different now, though. First of all, the salary increase is not as abrupt as it was back in 2019. We've had some interim steps, which makes this not such a big change as we saw back then. Secondly, like I said, July 1 has already come and gone, and we saw no effective court challenges. So we'll just have to wait and see if something takes effect before January 1. Judges don't like to work over the holidays either, so I would expect that this time we'll see a change in mid to early December rather than waiting until 2 days before like we had last time. But if there is no injunction as of January 1 and this goes into effect, obviously the Trump administration isn't going to be in place until January 20th. And I do think it's highly unlikely that there's going to be a revocation later if this law goes into effect. No politician does well when they make changes that result in their employees being paid less. So I think if we get past January 1, this is a salary threshold that will continue to be in effect. The other change that this law has is that instead of waiting around for Congress to take action, which is the previous format, it's going to result in automatic increases every 3 years. So the new salary levels are going to be published at least 150 days in advance to be able to give employers time to catch up. And it does permit the Department of Labor to delay those increases if we have a recession, if we have another pandemic or some other circumstance that really changes the financial outlook of the company. So this portion of the law, this is also subject to challenge. It certainly could be, we could see these automatic increases go away, especially because the agencies are having less power with the Supreme Court to be able to make those decisions. So this is one aspect of the law to where if we do see an injunction, it could certainly affect this automatic increase provision. As I mentioned, there are a few legal challenges. Some of them are pending in district courts in Texas, but those injunctions do take effect nationwide. So they will still impact employers here in Ohio and Michigan if those challenges are successful. Other changes in regard to wage and hour is that we could see an increase in minimum wage. The Trump administration seemed favorable to a federal minimum wage increase. Again, at least that was campaign speak. We'll see if that occurs. Right now, the federal minimum wage is only $7.25. A lot of us in Ohio and Michigan sometimes forget about that because we have state minimum wages that we have to deal with. But that is a potential change we could see that could raise the level above where our states are now. The other change that was discussed during the campaign was no employee taxes on overtime or tips. If that occurs, I can pretty much guarantee that the employer portion of those taxes will likely remain in effect. So employers will still be required to pay their portion and pay Social Security and the other associated taxes with those wages to the extent they are eventually exempt from employees. The big question, though, is how is that going to be done? Is it going to be done at the time of payroll processing where those wages are just passed on without tax? Or is it going to require the employee to seek a refund of those amounts at tax time? Most pundits are saying it's the latter, that they're going to expect a refund at tax time. And the reason for that is it does lower the overall price tag because there are a number of employees who just don't file tax returns at all. So we could see that type of change. If that's the case, that means employers are going to have to revise their W-2s to have a separate column that shows overtime pay so that that amount can be deducted at tax time by the employee. If that's not the case, we still need to make sure that your payroll systems are equipped to be able to stop taxing on that overtime or the tipped wages if that's the type of change that would occur. Fortunately, if we see legislation in that regard, it is going to be pushed back far enough to give us an opportunity to analyze how to make those changes. The next impact that we will likely see as a result of the election is that what I refer to as our patchwork quilt of employment laws is just going to get larger. We heard repeatedly from all Republican candidates that their desire is to take power away from the federal government and leave everything with the states. While that can be appealing for many reasons, it is less appealing from an employment law standpoint, especially if you are an employer who operates in multiple states. So instead of seeing a lot of federal change at the employment law level, we will likely continue to see an increase in changes at state levels, which can make compliance difficult for many companies. We'll see this in a couple of particular areas. First are related to accommodations and paid leave laws. And secondly is the regulation that was attempted to be put in place by the FTC on non-competition agreements. Let's just talk about those a little bit. So one question we get all the time here at the firm is that someone will call and say, look, I have an employee who wants an accommodation or a leave of absence. What am I supposed to do now? And currently, again, we have federal and state laws that we have to deal with. On the federal side, we have the Americans with Disabilities Act, which requires us to grant reasonable accommodations to employees with disabilities. And those reasonable accommodations can sometimes include paid time off or unpaid time off, depending on our policies. We also have the Family Medical Leave Act, which requires 12 weeks of unpaid leave and benefit continuation for employees who have worked at companies for over a year, if those companies have more than 50 employees or they're public employers. And our most recent ad under this federal column is the Pregnant Workers Fairness Act. The PWFA gives employees a lot of the protections of the ADA, but it goes a little farther in that it expands that protection to give automatic accommodations in some cases, and it's not necessarily limited to pregnancy. It's also related to any condition that's related to pregnancy. So arguably that can include things like infertility treatments, menopause, and other issues faced by women as a part of their health care. On the state law side, we have an increased number of states that have paid leave laws. Right now, we're up to about 19 states, so we're approaching half the country having some kind of paid leave available to them. Michigan, of course, is one of those. We're about to see some changes to Michigan's Earned Sick Time Act to expand to apply to more employers, so both big and small employers, and it's also going to increase the amount of paid time off from 50 hours to 72 hours. So that is another aspect that we're dealing with here in this region, but like I said, we're seeing it increasingly across the country. Some states also give additional time off for unpaid leave, and this can apply in a wide variety of circumstances. Some states have bereavement leave that's required by law, organ donation leave, school leave is also something we're increasingly seeing. So all of these things are something we need to consider if we have employees working in multiple states. We also have a new concept called state FMLA. So this is in a number of states as well. This is actually in over 20 states in some way or another. Some of these state FMLAs apply just like paid leave laws, except typically the leave is unpaid, where we have to give employees a certain amount of time off to attend to sick family members or their own health. Others are much more expansive and actually require paid time off in a manner that's similar to what we think of now for unemployment compensation. Employees and employers are required to pay into a general fund, and that is then distributed to employees if they need to take time off to care for themselves or their families. Right now, we're up to about 3 or 4 states that have this. Of course, California is one of them, but we're seeing it in other areas as well. And then finally, the states have differing standards for accommodations. So some states specifically state that if we give an accommodation to a workers' comp person in order to give them light duty, we then have to give it to any disabled employee. And that's a departure from what we're used to in this area of the country, where we often use those modified work programs to try to mitigate our workers' comp costs. So I'm going through all of this because we're seeing it, all of these state laws apply. Certainly Michigan and Ohio have some of them, but we're also subject to these laws if we have employees working remotely in one of the states that have these differing leave laws. So it's not a requirement that my company be located in these states to be subject to them. Most often, if I have one employee in California, for example, I therefore need to comply with these laws. Now, it's not a matter of where the employee is living, but it is a matter of where they're working. And with the increase in the remote workforce, this is something that more and more companies are dealing with in a way that they did not expect. We will only see this increase, as I mentioned, since there will not be federal legislation addressing these topics. So states are going to continue to add on to their existing state laws to make, further distinctions. Just in the past few years, we've probably seen 10 states add some sort of paid leave law, and that's only going to increase. So when we're dealing with these requests for reasonable accommodation, one thing we have to do is consider all of the things that could impact that situation. So in this first example, we have a pregnant employee tell her supervisor, "I'm having trouble getting to work at my scheduled start time because of morning sickness." So what law applies in this situation, and what are you supposed to do with this? Well, certainly the Pregnant Worker Fairness Act would consider this to be an accommodation that an employer would need to grant. It is possible that this is also an FMLA situation. So if this employee is subject to the FMLA, we might need to go through the process of seeing if she needs to certify that leave to alter her work schedule. And then finally, if you are a Michigan employer, this might also be a situation where the employee can use earned sick time to have those hours missed paid for when her morning sickness kicks in. So as you can see, there is not going to be a one size fits all. We're going to have to look at these things case by case, depending on what the situation is. The next example, employee who gave birth 3 months ago tells the person who assigns her work at the employment agency, "I need an hour off once a week for treatments to help with my back problem that started during my pregnancy." Again, this is a Pregnant Worker Fairness Act issue, even though the employee had already given birth, because it is a complication following the pregnancy. And although the employee works for an employment agency, the company where she is placed likewise has an obligation to comply with the PWFA because it is considered a joint employment relationship. So this is another example where we see the PWFA intersect with the ADA, because this could also be considered a regular disability under the ADA. And yes, once again, we could have the FMLA and earned sick time applied to this as well. Next one is employee's mom calls HR on employee's behalf and requests light duty for the employee due to a lifting restriction related to pregnancy. This is another little complication of the PWFA. Typically, we would not let someone's mother call in for them to request these types of accommodations unless the person was actually incapacitated. But the PWFA is much more expansive than other types of employment laws. So it does permit an employee to have a family member or other close relative or even a friend call in on the employee's behalf to make these types of requests. So that's another little wrinkle that we're not accustomed to, that the PWFA specifically provides for. And then finally, employee verbally informs a manager of a need for more bathroom and snack breaks because she's pregnant and has type 1 diabetes. Here, the need for bathroom and snack breaks because of pregnancy is protected by the PWFA. But even after the pregnancy is over and any type of childbirth complications are over, this is an accommodation that may still need to be granted because of the type 1 diabetes, which would be an ongoing condition. So here's where we have an intersection. Again, this doesn't mean that you have to just take every request from your employee and just adopt whatever accommodation they need. In most cases, we can require medical documentation from those employees to make sure that they have a legitimate issue and that the accommodation is going to address whatever that issue may be. Now we have to be careful on how we ask for that because there are limited circumstances for us to ask for medical accommodation due to medical information due to privacy reasons. But the point is, we don't have to just do everything our employees tell us to do. We do have some discretion and control over the process as long as we do it in the right way. So the moral of the story is this is one big web. And it does take a lot to navigate. We do have to look at multiple laws, federal law and state law. We can't just implement these on a one-size-fits-all basis. So when you're doing this, make sure you're working with experienced HR people or with your employment counsel to make sure you're not missing one of those pieces, because it is a lot to keep track of. And I think it's going to just get more fragmented given the lack of federal oversight on this issue. All right, so what do you do going forward? First and foremost, you want to make sure that you are training your supervisors and managers, and I cannot stress this enough. The people who handle HR for your companies, or that if you don't have an HR department and the owners handle that issue, they typically don't mess this up from what we see. The people who mess this up are frontline supervisors and managers, and that's because they just are not equipped to understand all of the nuances of these issues. What your supervisors and managers should be trained to say is go talk to HR or go talk to whomever is handling these types of disability and leave issues for your company. That's important for a couple reasons. As I mentioned, they're not equipped to do this. And second of all, these laws specifically state that these positions should not be doing it. Excuse me, because they're not supposed to have the private information of their employees if they are directing them on a regular basis. So make sure you get that training in place. Secondly, make sure that the people who are doing this understand how to identify an accommodation request. And this is where that training for supervisors and managers comes in, because typically the employee is going to go to their frontline manager with these questions. They don't have to come in and say, I want an accommodation or I want a leave of absence. What they have to do is give you enough information to put you on notice that they want some kind of accommodation. So, I need to have a doctor's appointment for this condition on a regular basis. I'm going to have surgery in a couple of months because my back is bothering me. All of those things are enough to trigger either the ADA interactive process or even an FMLA request. But we need to make sure that our managers and supervisors know that so they can report it back to HR so HR can follow the proper procedure. I would also encourage you to grant simple requests when people have an accommodation. If someone is asking for a stool to sit down because of a pregnancy or because, they have a bad back, if there's nothing about the process that prevents them from doing that and it doesn't create a business complication, by all means, just grant those simple and inexpensive requests whenever you can, and make sure that you're just documenting that for their file. Those are not situations where we need to go get medical documentation. Those are things we should just do as a matter of course whenever it's easy to do so. The reason for that is A, it improves our employee relations, certainly. But secondly, if we do have a tricky disability situation where we have to say no, we want to have lots of examples where we have accommodated other employees so we can later show that this is not a discriminatory decision. We also have to make sure that we're documenting every step of the interactive dialogue with employees. So what do I mean by that? That is the interactive process that's required by the ADA and most state laws. So if an employee has a medical issue, we're required to sit down with them, understand what they need, explain why certain things will work or will not work, and get medical documentation if we need, if necessary. That's required for every employee. So make sure that we're documenting that in the employee's medical file. So if there's later an issue, the company can show that it fulfilled its obligations under the law. Now, it may be that you'll go to the employee and say, okay, I need medical documentation to substantiate what's going on here. And the employee just never comes back never gives you any information. Again, if that is documented, that is the best defense for a company in an ADA or an FMLA situation, because the employee is responsible for that breakdown in the interactive process, not the company. And again, that will be very, very valuable if you ever need to defend a claim. Provide interim accommodations whenever possible. So sometimes under the ADA or the Pregnant Worker Fairness Act, some of the accommodations that might be required could take longer than you would expect to get into place. So for example, I just spoke with a client earlier this week who was granting an accommodation for an employee who needed a special seat installed in a forklift because of a back problem. They were fulfilling that employee's request. They had the medical to back it up, but it was taking a while to get that seat installed. So in that case, what the company did is they documented the fact that they permitted an employee to bring in a special cushion, which would serve as a temporary accommodation. That way, if the employee later claimed, look, you're not accommodating me, I asked for this special chair months ago, they can show that they were taking steps to get it ordered and also trying to accommodate the employee in the interim. And then finally, of course, understand the interactions between the federal laws and the state law. Whenever we're dealing with a leave of absence or medical issue, we need to be thinking about all these things. They might not always apply, but you just want to go through the list to make sure you're not missing anything. These can also apply in a workers' comp issue. So if you have an employee who's out on workers' comp and they are eligible for FMLA, then by all means, make sure you're getting them the FMLA documentation so that they're exhausting FMLA leave at the same time as the workers' comp leave. You don't want to be in a situation where the employee is out for 4 months on workers' comp, and then they come back to work and have 12 weeks of FMLA available to them as well. Those leaves can run concurrently, and they should, whenever all of those criteria are satisfied. Okay, another issue that we'll probably see some new changes to is in the area of non-competes. Michigan and Ohio do uphold non-competition agreements where they're not overly broad and that they're focused on unfair competition rather than all types of competition. You've probably saw in the news over the past year that the FTC had passed a regulation stating that non-competes would be illegal nationwide, except for a very limited number of grandfathered agreements that were focused on CEOs and other executive positions. That was supposed to take effect this year, but an injunction was issued on August 20th of 2024. An appeal was filed by the FTC that is pending. Now that the Trump administration is coming in, that is almost certainly going to be abandoned. And we doubt that the FTC is going to try to continue to get this regulation pushed forward. So the flip side of that is that states will sort of fill that void as they have already. About half the states in the country have laws that address non-competes. Some of them, like California, invalidate them completely under all circumstances, similar to what the FTC regulation did. Others just limit them. Perhaps they're limited to people who are earning a certain amount of money or are in certain types of positions with the company. In those states that limit them in some way, it's important to know that if you try to enforce a non-compete agreement there, that in itself is a violation, and there are lawsuits that can be brought and penalties that can be imposed by those states if you try to enforce a non-competition agreement in those particular jurisdictions. So a lot of companies think that that doesn't apply to them because the non-compete agreement they use for employees says Ohio law will govern this contract or Michigan law will govern this contract. And since the non-compete is enforceable there, then it's going to be enforceable anywhere. And unfortunately, that's not the case. A lot of the states that limit non-competes also write into their statutes that courts will not enforce choice of law clauses if the state law that is being enforced is more expansive and permits non-compete agreements. So just using Ohio or Michigan law in your contract is not going to be sufficient. You can still run into the same problems. And that impacts employers again, regardless of where they're located. So if we have an applicant coming to our company who lives in a state that's subject to these things, they could have existing agreements that may be void because of the state law where they live. We also have to be careful to make sure that any remote employees that we bring into the company are not asked to sign a non-compete if they're working from a state where non-competition agreements are not allowed. So keep those things in mind if you use non-competes at your company. Fortunately, most states, again, not all, but most, permit non-solicitation clauses and confidentiality agreements. So those are still okay in most places. And with non-solicitation agreements, I mean agreements that prevent the employee from going after both employees of our company or clients of our company. So those are very useful tools if you do have an employee who is in a jurisdiction that limits non-competes, and this is a very sensitive situation. So sales, for example, or other very competitive types of positions in companies. So with all these different state laws, it is not uncommon for companies to have to use a variety of different agreements if you have a nationwide presence or if you have employees. This is another example where one size fits all does not typically work. And that's true even if you're all in Ohio. If you're asking all of your employees to sign a non-compete agreement, regardless of what position they hold at the company, that's probably not going to be enforceable because courts are looking to limit these agreements to positions that truly have a potential for harm from a competition standpoint. So make sure that you're reserving these agreements just for those positions that have access to that sensitive information, who can truly compete and harm your business. Otherwise, you could be invalidating all of your agreements if you're taking a one-size-fits-all approach. Finally, we have expected changes at the National Labor Relations Board. This is the federal agency that governs issues related to unions, and it also protects employees when they want to engage in protected concerted activity or explore whether to try to bring a union into your organization. So the NLRB is something that a lot of employers just kind of forget about if they're a non-union company because they think I don't have to worry about that. But the NLRB does impose a lot of policies that apply to non-union facilities. So all employers do need to be aware of the guidance. Under the Biden administration, the NLRB's activities were much more expansive. They changed the law and the regulations to have union elections be more easy to bring at companies, limited the time frame within which they were able to do that, and essentially gave the companies less opportunities to be able to show employees that a union may not be advantageous to them. There were also a number of changes to the types of employment policies employers were able to include at non-union facilities. So for example, confidentiality policies were very scrutinized because if an employee is prevented from talking about things like salary or benefits or conditions related to the workplace, the NLRB found that that was an impermissible limitation on their ability to discuss the terms and conditions of their employment with fellow employees. The NLRB also issued limitations on at-will employment policies and a variety of other policies that a lot of us had just routinely included in our handbooks for years. But they were finding that those policies constituted an unfair labor practice charge and they needed to be removed. Fortunately, with the Trump administration, we expect a pretty shift change in that regard. The NLRB is a very unusual agency because unlike other agencies where change takes a long time to put into effect because regulations have to go through or statutes need to be passed, the NLRB operates on a series of guidance memos. And with every administration change, the NLRB members are often replaced. So right now, we have 3 Democratic members of the NLRB and 1 Republican member. The Democratic member her term is about up, so that will likely be replaced by a Republican appointee when Trump gets into office. And the general counsel will be changed with the administration as well. So those are the entities that make these rules. We expect a lot of these memos to be revoked. And again, that's frustrating because we certainly went through and revised a lot of employment policies for our clients as a part of that process to get compliant with the NLRB. And under the Trump administration, those changes may no longer be necessary. We could also see some additional changes brought in as a result of that. And if that happens, we'll need to change pretty quickly because there's never a time period within which we have to comply with the NLRB. It's not like statutes or regulations where we have a little more discretion and a little more warning when these things happen. So that is another change we expect to see pretty quickly after January 20th. Okay, Stacy, did we get any questions?
We sure did. I think you struck a couple of nerves out there. Since we were talking about remote employees, boy, there sure are a lot of considerations. So one of the questions we have is if an employer has employees in multiple states, which state's non-compete law would be the standard used? So would it be the employee's state of residence or where the company is located?
So it's neither one of those. It is where the employee is working. So if the employee simply lives in Michigan and they drive to your office in Ohio, Ohio law is going to control because that's where the person is working. But if it is a remote employee who is living and working in Michigan, then the Michigan law will control. So that's going to apply on a nationwide basis.
Okay, great. Guys, if you have any more questions, feel free to add them. We do have a question on background checks. In fact, we have 2 of the same questions. So you used the example of somebody who is applying for a financial role, shouldn't have a financial crime. Totally makes sense, right? That goes together. What about if you have a general labor in the plant who has a felony for something violent? I mean, employers we all want to keep our employees safe. How do we handle something like that?
So this one would typically involve sitting down with the employee and talking about what happened. Whenever we go through this analysis, it's very similar to the interactive process under the ADA. We want to get additional information from the employee to understand the specifics of how the conviction occurred. We also want to take a look at when it occurred. So if it was last year and it was a murder or something extremely violent, you're going to have a pretty good argument that that's not someone you want in your facility because of the safety of the employees and from an employee relations issue, because all criminal matters are public records. So other employees can find out about this as well. Now, if it was a general assault that happened after a bar fight and it happened 10 years ago, you're going to have a much harder time keeping someone out of the workplace with that type of issue than something that happened much more recently and which was much more serious. So you're always looking at it from a proportionality standpoint. How long ago did it occur and how egregious was the violation? And again, is this someone who's going to be working with employees very closely on a day-to-day basis? Or is this someone who is going to be pretty much working on their own? They're not going to have a lot of interaction with other employees where that argument about safety is not as strong.
Okay, great. Well, thank you for all of this information. I think my left eye was actually twitching a little bit as you were going through some of it. So I have to apologize to our audience. We did have some technical difficulties on the chat, and Lynn did a really nice PowerPoint presentation that apparently was not cooperating today. So I will send that to you this afternoon along with your HCRI credit and Lynn's contact information in case there's any other questions. I'll be happy to connect the two of you. If you would like the recording, contact your advance rep or respond to my email. I'd be happy to provide that to you once it's ready. And we are excited to be able to have these thought leadership series on a quarterly basis. We're going to take some time off over the holidays and get back at it after the holidays in Q1. So be on the lookout for our programming mid Q1. And thank you very much for your time and your talent, Lynn. We do appreciate it. And I hope everyone has a wonderful afternoon. Thank you for joining us.
Thank you.